webinar series on investor-state dispute settlement reform at Crossroads. My name is Lukas Schaugg. I am a policy advisor in ISD's investment law and policy team. I'll be moderating the session today on multilateral investment treaty reform. Where are we today and where should we go? A few housekeeping points before we begin. Like last week, this session is being recorded and the recording will be made available on our event page right after the session. You can also access the recording of the first session on this page, the link of which we have or will be putting in the chat in a moment. Please submit your questions at any time using the Q&A box at the bottom of your screen. The panelists and I will try to address as many of your questions as we can in the final segment of the discussion today. We will also share any resources or references mentioned via the chat. So now let's come to the topic of our discussion today. Today's conversation builds directly on last week's first session. There we heard concrete case studies showing how the current ISDS regime can impede public interest regulation, distort the polluter pays principle, and entrench asymmetries in access to justice. We also discussed how tribunals often give limited weight to the perspectives of local and indigenous communities, how investor rights are often prioritized over human rights and environmental protection, and how the recent ICJ advisory opinion on states' climate obligations may influence investment dispute settlement in the future. At the end of the first session, Lise Johnson tied things together with a simple framing. Responsible business conduct, she said, relies on three levers: legal mandates, normative guidance, and market signals, and investment treaties have a track record of undermining all three. So today we pivot from this diagnosis to direction. Our goal is to take stock of 4 reform tracks at the multilateral and EU level and ask what will actually change in practice. At UNCITRALWGIII, states have been discussing a package of procedural reforms, including a standing mechanism and procedural and cross-cutting issues since 2017. At the OECD, as part of track 1 of the work program on the future of investment treaties, governments and experts have been exploring substantive reform options, such as a fossil fuel and a climate change carve-out, as well as a positive agenda for investment treaties going forward. At UN Trade and Development, the emphasis has been more on system-wide coherence, stock-taking of treaty practice, guidance on damages and dispute settlement, and support for states dealing with legacy investment treaties. In the context of the European Union, withdrawals from the Energy Charter Treaty have reset the politics, but complex questions remain about legacy protection inside the EU and the member states' old generation BITs with third states. So across all of these processes, we will be asking the tough questions today. Will these efforts be able to deliver the change that is needed to address today's most pressing challenges? What legal options are there to apply reforms across what is a complex web of over 2,000 existing investment treaties? And perhaps the most important question of all, especially in light of the progressing climate crisis, will these reforms deliver in a time frame that is short enough to provide the policy space for the unprecedented climate action that is required? So to unpack some of these issues, I'm very pleased to be joined today by 4 experts whose work focuses on the front line of investment law reform and governance in the public interest. First of all, we're joined by Dafina Atanasova, who is an economic affairs officer at UN Trade and Development. She advises governments on treaty reform and dispute settlement approaches, contributes to the World Investment Report and other publications on international investment agreements, and she helps build consensus on sustainable investment policy through UN Trade and Development platforms. Dafina, thank you very much for joining us today. Next, we have Günes Ünüvar, who is a senior researcher at the Luxembourg Center for European Law at the University of Luxembourg. His work spans international investment law, state capital, and cross-border investment, as well as questions of corporate responsibility. Günes has closely followed UNCITRALWGIII on ISDS reform and previously served as a senior research fellow at the Max Planck Institute in Luxembourg. Thank you very much for joining us. We're also joined by Joshua Paine, who is an associate professor in international law at the University of Bristol. His research covers investment law, trade law, and international adjudication. Josh's work on a climate change carve-out for investment treaties won the 2023 John H. Jackson Prize, and he has presented at OECD conferences and the European Commission, as well as given evidence to UK parliamentary committees on matters related to investment law. Welcome to the panel, Josh. And last but not least, we are joined by Clémentine Baldon, who is the founding lawyer of the law firm Baldon Avocats in Paris. She advises NGOs, companies, and public bodies on legal strategies that advance the ecological transition, with a practice at the intersection of EU law, investment and trade, and climate-related litigation. She's an expert on the ECT and also assisting efforts to request an infringement procedure against EU member states maintaining outdated BITs. So thank you all for joining the discussion today. Before we start, I would like to emphasize that all our speakers are speaking in a personal capacity today. Without any further ado, let us begin with our first round of interventions, which will consist of lightning inputs on the major efforts to reform ISDS and investment treaties. And we will start with Dafina, who will give us an overview of the state of play in global IIA reform. Dafina, the floor is yours.
Thank you so much, Lukas. And while I just share my screen, allow me to thank you and Planet Earth for the kind invitation and for hosting this timely webinar. The topic is key. It is something that we're all thinking about. So thank you for bringing us together so that we can discuss it and hopefully move forward. So talking about the state of play of the reform of the international investment regime requires telling two parallel stories. One, somewhat more positive and happy. That is the story of what we see in new generation treaties, in recent treaties. And then another one, which is a bit less optimistic, which looks at the bulk of old generation treaties that are still in place. To go through both of these, I'll start with the positive one. In good spirits, we are just starting the webinar. Let's keep the gloom for a bit later. And what we see in our research in the past years is that when we look at recent treaties, at treaties that have been signed in the past 5 years since 2020, there are at least three types of developments that we see. One, the focus of the treaties is changing. Two, the content of the treaties includes more reform features. And three, we have a move towards exiting or towards disengaging with certain old generation treaties by a number of actors. So turning to the focus of the investment agreements, what we see is that while old generation treaties were firmly focused on protection, we now have more treaties that include facilitation and cooperation provisions than those that focus on protection. Protection is still prominent. It is there in over 60% of treaties, but you do have that cooperative and softer approach that's gaining ground. Similarly, while liberalization and promotion were clearly the exception in old generation treaties, nowadays, while in minority, they gain ground as well, moving for promotion, for instance, from 5% of treaties to close to 30%, for liberalization from about 15% to about 40%. So these are developments that show that policymakers are looking for a new formula, for additional formulas in how to design treaties that respond to their policy questions and the policy problems that they face in the international investment sphere. In addition to that, what we see when we look more concretely at the content of these new treaties is that they first contain much more safeguards for the state's right to regulate when we look at protection standards. And that includes also the key standards that are most commonly litigated in ISDS, including fair and equitable treatment standard. Now close to half of treaties either include a closed list or omit the standard altogether. And the similar trend we can see in relation to indirect expropriation. We also see that close to half of new treaties do not include investor-to-state arbitration. Now, that trend, of course, is linked to two combined factors. One, the diversification of content, of focus of the treaties means that ISDS is less relevant for such provisions as facilitation, as liberalization. It has been typically included for protection, but it is quite telling that about 50% of the broad economic agreements signed in the past 5 years that do include protection provisions still omit the investor-state arbitration. Similarly, while much less common, some BITs are going towards that path as well, and examples are the Australia UAE and the New Zealand UAE BITs concluded recently. Investment treaties are also more and more including sustainable development provisions. And this is a welcome trend. It is quite diverse. It includes provisions that preserve regulatory space, those that relate to cooperation on sustainable development, provision on sustainable development issues between the parties, labor, environment, those that go for that aim to encourage responsible investment or require responsible investment, or those that would like to make the treaty more inclusive towards communities that have typically not been able to benefit from these international agreements: women, local communities, small and medium-sized enterprises. And this is a very welcome development. What we are looking forward to seeing is for some of the more effective provisions within those sustainable development options, such as investor obligations, clear ones, or treaties that define their scope in relation to sustainability to become more common. But it is still a positive step to see those provisions included, while 10 years ago this would not have been on the board, neither investor obligations nor a treaty that defines itself in relation to a sustainability criterion. Now this is part of what we are finding in writing in treaties that are already in force for some of them. And then we again see divestment from treaties that are no longer fit for purpose according to the parties to them. Terminations have reached close to 600 in the past decade, including for climate considerations. A big part of that, over 200, is related to the termination and phase out of intra-EU bilateral investment treaties, where the EU considered that this is no longer needed. Bilateral investment treaties are not needed in the context of the regional organization, and I'm sure that Clémentine will say more about that. But we also have the withdrawal from the ECT by several EU members and the EU itself, and actually by several other countries outside of the EU. We have countries that have terminated their agreements with the idea of exiting the investment agreement system, such as Bolivia and Ecuador. We have others who have terminated with the idea of starting from a clean slate, such as Indonesia and India negotiating now new agreements. And so with this somewhat active and burgeoning picture of reforms at different places, what we still see is that the investment regime looks like this. Agreements from the 1990s and 2000 continue to dominate the regime by far. And here I move to somewhat more the gloomy side of my presentation and the parallel story of what is happening. Because what we talked about so far, what I presented so far, only affects the treaties in the little square, yellow square at the bottom right. While 85% of all international investment agreements in force are still old generation ones. 97% of investment disputes continue to be based on old generation agreements. And countries have been slow to modernize their old agreements. There are less than 60 treaties that have been replaced by a new agreement since 2012. And with this, the bottom line of, in a sense, the state of play is that we are seeing a growing dichotomy between old and new agreements, and that tackling the old agreements is key in order to make a dent into the core of the functioning of the regime. So thank you very much, Lukas, for allowing me this time and allowing me to use slides as we had discussed previously, and I give the floor back to you.
Thank you so much, Dafina, for this very useful and very impressive overview, and for starting the discussion on a positive note while ending your presentation by grounding us in the reality of the progress of IIA reform. I would like to remind everyone that, the panelists, that we should stick to 4 minutes for your interventions, if possible, and would like to turn to Günes now. So more than around 50 state delegates have been meeting at least twice a year in Vienna and New York to achieve a multilateral reform of ISDS under the auspices of UNCITRAL. Where, in your view, do discussions at Working Group 3 currently stand, and what outputs could be operational soon?
Thank you, Lukas. I don't want to digress from the outset, but I'm very happy that Dafina referred to the changing IAAs as the good side of the story, but I guess we'll come back to that. I fully agree on that point. So my name is Günes, and I've been attending the UNCITRAL Working Group 3 meetings on behalf of the Center of Excellence for International Courts in Copenhagen, University of Copenhagen. And I've been attending since 2018, if memory serves, when the delegates were discussing whether or not reform was desirable. So pretty much, you could say the beginning, the operational inception of the Working Group 3. And the current mandate started in 2017, as is probably common knowledge. It is to consider, or it still is, to consider possible reform solutions to the existing ISDS system. And again, I'm sure, common knowledge. It's criticized for being, the awards are being criticized for being inconsistent, costs as being excessive, there's lack of transparency, as a perceived imbalance between investor protection and states' right to regulate, etc. But this is a more holistic sort of overarching criticism. And now the Working Group 3 has moved to what it's called the third solution-oriented phase a few years back. So the focus is now to develop concrete texts, institutional mechanisms, international instruments that could make the system hopefully more transparent, the awards more predictable and coherent to some extent, and development-oriented. I think that's the key aspect in light of this panel today. It's an incremental but also cumulative process. Each reform track feeds into a larger architecture, which aims at modernizing how investment disputes are being resolved. And I think it's also important to say from the outset that it's part of a broader reform effort. That's why I think it makes a lot of sense to discuss this in the context of what's being done in UNCTAD and what's being done under the auspices of OECD. So very quickly, the first, I would say, probably the most important, the most overarching element of this UNCITRAL process is the multilateral instruments. this multilateral instrument of investment dispute settlement reform. A full draft is on the table as of the beginning of this year, if not even earlier, but it's been on the UNCITRAL webpage since the beginning of this year. It's a very interesting document because it's a framework convention. And this is not something that we see very often in investment law, investment arbitration. There are optional protocols, basically a central module that can have additional modules. And this, of course, gives states a much desired, historically speaking, much desired flexibility to opt into specific reforms, and such as the new procedural rules or institutional mechanisms or the code of conduct for judges or arbitrators, depending on their choice of adjudication mechanism. And in a way, it also allows them, I think this also goes to what Dafina said about the dominance of these 1990s treaties, that it sort of is capable of applying in retrospect, that the states can sort of update, if you will, the software of these very much analog 1990s treaties, which is a very innovative way of thinking, at least, from a procedural standpoint. Then we have a standing mechanism that's on the table. We have a draft statute which envisages a two-tier system composed of a first instance tribunal and an appellate body. Of course, if you are at any degree familiar with investment law scholarship, you'll know that the appellate system is nothing new, but it's concretely on the table now. And now, very much recently, in the last week or so, we have, or maybe a bit earlier, we have the European Union submission on jurisdiction, which is also significant, but we'll come back to that. I don't want to go too much into detail. Then we have the cross-cutting and procedural provisions on evidence, bifurcation, consolidation and coordination, counterclaims, denial of benefits, damages, right to regulate joint interpretations, etc., which is very much, it sits at the nexus of what you could consider procedural and substantive. And then we have discussions, of course, a key, an elephant in the room, if you will. Damages and compensation is a very, very important issue, and probably one of the main points of contention between what we can call capital exporting and capital importing countries, even though it's a very simplistic way of putting that. We have a number of completed deliverables as well, and I'll finish with that. We have a code of conduct for arbitrators and judges. We have the statute for an advisory center on international investment dispute resolution, with a couple of meetings on the operationalization of this center. These all will be sort of protocols along with the draft texts that are currently on the table. So Working Group 3 has evolved from sort of diagnosing, if we can say that, the shortcomings of ISDS, to sort of constructing some procedural, albeit limited, foundations of this sort of new system. And it's yet to be seen, of course, where this will lead, but I'm not entirely pessimistic about the future. Thank you.
Thank you very much, Günes, for bringing us up to speed on the work of UNCITRAL Working Group 3 and for alluding already to the complexity of the implementation of this endeavor. Josh, I would like to now turn to you. The OECD has complemented efforts at UNCITRAL that are, of course, focusing more on the procedural side by providing a space to discuss options of substantive treaty reform, or this is substantive aspects of treaty reform, with a view to climate and environmental policy. Could you give us an overview of the concrete options that have been discussed at track 1 of the OECD work program?
Thanks, Lukas. So there's essentially 3 categories or groups of reform options that have been discussed in the OECD Track 1 process. Firstly, there's the question of whether investment treaty benefits should be either removed or reduced for fossil fuel sectors. This aspect of the process has drawn on the idea of climate alignment for finance flows, which is an obligation of the Paris Agreement in Article 2.1c. Part of the Track 1 work has been doing conceptual work on how this obligation in Article 2.1c of the Paris Agreement may apply to investment treaties. for example, drawing on experiences of climate alignment in adjacent areas such as political risk insurance. This aspect of the OECD process has also drawn on the so-called flexibility mechanism that was introduced in the Energy Charter Treaty modernisation. The idea of sectoral carve-outs for fossil fuel investments has been controversial, with many governments participating in the OECD Track 1 process. The concern, as I understand it, is that such a carve-out is potentially overly broad, because it would remove treaty protection both for climate-related measures, but also for all other types of measures in relation to the sectors covered. The second category of reforms that have been discussed in the OECD Track 1 process are reforms to protect government's policy space in relation to climate-related measures. Here, in addition to fairly standard discussions around clarifying standards of treaty protection or adding exceptions, one of the distinctive proposals to arise from the OECD process have been proposals for a climate policy space carve-out from ISDS. So in work I've done with a co-author, Elizabeth Schaugg, we developed a proposal for a climate policy space carve-out from ISDS procedures. That idea was originally set out in an article we published in the Journal of International Economic Law in 2023. And that article drew on our individual submissions to the initial OECD public consultation in 2022. Then in early 2024, we developed draft treaty provisions and commentary, which were circulated to governments and discussed at the OECD 2024 Investment Treaty Conference. Those provisions are available online, and I think Lukas has nicely put them into the chat for me. Now, I don't want to go into our proposal in huge detail here because it's not the focus, but just to say, I think arguably the most important aspect of what we propose is the process to govern the application of the carve-out. So under the process we propose, where a respondent government views an ISDS claim as covered by the carve-out, it would be permitted to refer the question of whether the carve-out applies to the designated environmental authorities of the treaty parties, who would have a period in which to consult and attempt to reach a joint determination. And where they could not reach a joint determination on whether or not the carve-out applies, either treaty party would have the option of referring that question to an independent state-to-state panel that would include members with climate expertise. Importantly, our proposed process does not allow either treaty party to decide unilaterally on the application of the carve-out to investor claims. The third set of reforms that have been discussed in the OECD Track 1 process is what was already touched on and is referred to in Track 1 as the so-called positive agenda. This is essentially the question of how investment treaties or other kinds of international agreements may have some role to play in either facilitating or promoting investment that addresses the problem of climate change. As some of you will know, the OECD has recently done a second public consultation that closed in late September and that was focused specifically on this positive agenda question. The kind of issues discussed in Track 1 in relation to the positive agenda have included, for example, investment facilitation or investment liberalisation commitments in clean energy sectors. Here, just to kind of give you a sense, Track 1 discussions have considered newer forms of investment-related agreements that have relevance for climate-related sectors. For example, agreements on investment facilitation, non-binding green economy agreements, or the 2024 Agreement on Climate Change, Trade and Sustainability. The latter covers investment to some degree because it includes commitments on trade and environmental services. So to sum up, the questions discussed in Track 1 on this third aspect, the positive agenda, I think largely boil down to what role, if any, international agreements have in facilitating or promoting investment in clean energy sectors. I'll stop there and hand back to Lukas.
Thank you so much, Josh, for presenting the options discussed at the OECD, to which you also made a major contribution, and that are specific to the climate dimension of investment treaty reform. I will now turn to Clémentine to address the status quo of the Energy Charter Treaty, the withdrawal from which is another process that has specific implications for climate policy. The attempted modernization and also the subsequent wave of withdrawals from the ECT was without a doubt the most publicly visible process in investment treaty reforms, at least in Europe in recent years. So, Clémentine, what, in your view, are the implications of the fact that only some states have withdrawn from the treaty for investment protection in the EU and its neighborhood?
Thank you, Lukas. I'm really happy to be here. Thank you for the invitation. So maybe before answering your question, just a quick reminder of where we stand now with the Energy Charter Treaty, because it's been a bit complex to follow. So now, as you mentioned, so there has been this wave of withdrawals of EU countries, which was motivated by the fact that the growing acknowledgement of the detrimental effects of the ECT on the climate transition, including by the IPCC, UN, the European Parliament. So now we have had some member states that have withdrawn: Denmark, Lithuania, Spain, Luxembourg, Netherlands, France, Germany, Poland, Slovenia, Portugal, and also outside the EU, the UK and Norway. And we have some member states that are remaining within the ECT, Czech Republic, Latvia, etc. So the EU itself, as it was mentioned, withdrew and agreed that some member states can remain within the ECT if they want to. And meanwhile, at the same time, in parallel, the modernization of the ECT has entered into force since the 3rd of September, at least some of the amendments. So we have really a patchwork of different coverage with some member states, EU member states within the city, some other outside, and also modernized provision versus all provision. So what's the implication? So for intra-EU investments, actually, that doesn't really change because as you know, we have this very important ruling from the European Court of Justice, Schaugg, which ruled that intra-EU disputes should not be ruled by the ECT, and that the awards were incompatible with EU law. So that's why the majority, the EU courts are not supposed to recognize awards rendered under the ECT in intra-EU dispute, but this does not apply to courts outside the EU because the majority of ECT tribunals have not felt bound by this ECT ruling Schaugg, and they have failed to decline their jurisdiction, and some courts outside the EU still recognize and enforce these awards. So now the revision of the ECT has made things clearer because now it has been revised and it now explicitly states that it does not imply to intra-EU disputes. So maybe things will change in relation to this. And also very recently, the EU and member states have concluded an agreement on 10th September, which states that ECT should never have been applied as a basis for intra-EU arbitration proceedings. So this is already complex intra-EU disputes, but this hopefully will become clearer. And even if we are not very clear as to how the enforcement of intra-EU awards will, how it will be treated outside of the EU, and we still see new cases initiated under the ECT, even including intra-EU disputes. So we will have to wait and see. And now for extra-EU investment, this is where really this change, this withdrawal from the Energy Charter Treaty have an important implication. So for member states that remain within the ECT, there's no change. With the third countries will still be able to base their complaints on the ECT. For member states which have exited, then the real concern is what is called the sunset clause. You know, this provision in the Energy Charter Treaty and that you find in most investment treaties that grant the protection to pre-existing investment to 20 years after the withdrawal of the state. So this really diminishes the impact of the withdrawal of countries, and that's why this would be important for member states to be really consistent with their decision to exit the ECT, to make effort to neutralize this sunset clause, at least with the countries which have exited, for example, the UK or other states. That will be really important to be effective. But in conclusion, to be brief, we really face an incredibly complex situation with this patchwork of coverage and norms, both within and outside the EU. And really that brings some kind of legal uncertainty, and that would be really important, at least to address this issue of the sunset clause for member states and the EU which have decided to withdraw the ECT. Thank you.
Thank you very much, Clémentine, for laying out the complex aftermath or landscape post partial withdrawal from the Energy Charter Treaty. I would like to now move to the second round of questions, where we want to delve a little deeper into the intricacies of the different options for reform that are being discussed at these various levels and in these various fora. I am mindful, though, of the time that's advancing quickly, and we have around 25 minutes left for this second segment to leave some time for questions at the end as well. So I would like to remind the panelists to limit their interventions to around 4 minutes. And with that, I'm turning again to you, Dafina. So while there is considerable innovation in recent treaties, as you also demonstrated in your initial presentation, the vast majority of existing old generation treaties that provide unqualified consent to ISDS remains intact. So in your view, what is the most viable way to address this legacy problem?
So thank you, Lukas. And I think that here my answer will be clearly influenced by the place where I work currently. Meaning that at UNCTAD, what we see on a day-to-day basis is the tremendous potential of regional reform in addressing a number of these issues, both of old generation treaties, but also looking forward and consolidating and harmonizing the investment regime in various blocks, which are attuned to the cultural and economic realities of the regions in question. And we see the effective work that can be done by partnering with regional organizations such as the African Continental Free Trade Area, League of Arab States, COMESA, the Organization of Islamic Cooperation, which are all doing ongoing forward-looking, but also backward-looking reform efforts. Now, in addition to that, of course, regional reforms cannot tackle all aspects of investment governance because there are interregional agreements. And that, for us at UNCTAD, has been the reason why looking at reform at all levels has been necessary, meaning bilateral, regional, and multilateral engagement where there is a multilateral option for it. We tend to focus, and that is an additional feature of the realities of how the regime works, on reform that is not based on isolated aspects, but is synchronized to all policy dimensions of the regime. So starting from the interplay of novel aspects of the regime with aspects of old generation treaties and how those interact together. And that has been something that has brought us to consider that a continued engagement through consensus building platforms is something that is necessary. It is not the only way forward, but putting people in the same room through a truly universal forum such as the IAA conference that UNCTAD organizes or the platform on IAA reform allows for an inclusive dialogue and collaborative reform efforts that move towards that goal that we're all working for. And that has, in fact, informed the decision of working on guiding principles on IAA reform based on that experience in the past 10 years. Here, I give the floor back to you. Thank you very much, Lukas.
Thank you so much, Dafina. Günes, I would like to turn to you again. Regarding UNCITRAL Working Group 3, how would you assess the transformative potential of some of the proposals related to the procedural and cross-cutting issues, and in particular, the discussion of a possible reform of the award of damages and third-party funding at Working Group 3? And also as a second question, how convinced are you that the reforms that are discussed at UNCITRAL will deliver within the time frame that is required for compliance with the Paris Agreement?
Yeah, thank you, Lukas. It's a very important question, and perhaps it's important to start the answer with the caveat that the story does not begin or end with ISDS reform when it comes to climate change. It's a part of not only an international effort, but it's also joined by states' unilateral initiatives and willingness to actually take genuine action, right? So, like, it's important to distinguish that because I think that's the reality. Focusing specifically on the Working Group 3, I think the short answer would be that the reforms specifically on cross-cutting issues have transformative potential in principle, but their transformative effect, of course, in practice will depend less on the content of the texts and more on how quickly states adopt and operationalize them through this multilateral instruments. And let's, for example, start with damages. What the working group has produced, and I think it is given how contentious this issue is, it's important to emphasize that it's an attempt to sort of re-engineer how damages work, right? This is a very key discussion, and there was initially pushback towards pushback from certain states to say that damages is not within the mandate of Working Group 3. They didn't want to discuss it because they felt like we have a damages calculation, at least a framework that comes from customary international law. We're not here to change customary international law, etc. But I think this discussion can really promote more transparency, early case management. These tribunal appointed experts is a very important addition vis-a-vis party appointed experts, which is, in itself a controversial question. Are they part of the legal team that represent the party, or what exactly is the party appointed experts role? And techniques to sort of counter what I guess we might frame as cognitive bias or blind assessments, or let's say impulsive choices by arbitral tribunals. And if implemented, actually, these measures could, in principle, narrow the scope for speculative or inflated awards, which is really the primary problem with them, right? You don't really know the extent to which, as a state, what you might end up paying, especially in like high stakes disputes linked to environmental regulation or climate transition policies, which are systemic rather than targeted at one or two investors. And even if they seem to be targeted at one or two investors, like in the case of Rockhopper, even though the respondent state did not really frame the defense along those lines, you can see what an important effect and how much discussion it actually invokes. And if states, let's put it that way, if states feel somewhat comfortable or somewhat secure, this might decrease the chilling effect, and it might sort of prompt them to take more assertive action. But again, even without such chilling effect coming from ISDS, if a state isn't willing to act, they simply will not. There are countries which, in my opinion, are immune to this chilling effect, and they don't do 1% of what they should be doing. And it's important, again, to emphasize that this is a broader systemic issue, a global issue, and not just an ISDS question. Now, the same, I think, is also true, for example, for third-party funding. The draft provisions don't really prohibit third-party funding outright, but to sort of regulate it through disclosure, conflict management requirements, which is not something novel within the broader procedural framework. And there is also this perception that funded claims have sort of increasingly targeted environmental energy transition measures. These transparency obligations could bring a degree of accountability. I think this is also something we have to take into account. Now, timing, as you say, is a critical issue, and the climate urgency, as you rightly point out. UNCITRAL is a deliberative process by design, right? The multilateral instrument and its protocols will take time to finalize and ratify. That said, there are two realistic, maybe near-term pathways, if we can call them that. The states can begin voluntary implementation. That goes back to what I was saying. If states want to do something, they will find a way. And this shouldn't be an excuse, so to speak, that the multilateral instrument isn't in force yet. We haven't enacted this protocol. This is bigger than ISDS. And the second one is the soft law influence. There are a number of institutions, including IISD and Client Earth, that have ample documentation, ample resources. UNCTAD likewise. Like, this is out there online. At the distance of a Google search, right? These are science-based assessments. These are statistical, empirical work that can already benefit what states ought to do to go in the future. So I think focusing on the principles and what needs to be done is more important than focusing on finalizing a process and sort of waiting until a certain instrument or protocol takes shape. I think we know what we need to do already. Thank you.
Thank you so much, Günes, for outlining the need for a proactive approach. So Günes already alluded to the importance of a rapid implementation, and turning back to the discussions initiated at the OECD on a climate change or fossil fuel carve-out. Josh, in your view, how could such a climate change carve-out be designed? You already mentioned your work with Elizabeth Schaugg on this, to prevent ISDS from undermining legitimate climate policy measures in the future. And perhaps equally importantly, how could such a carve-out be integrated into the existing regime of old generation investment treaties that is dispersed, right? That is complex.
Thanks, Lukas. So starting with your first question, in my view, to be effective, a climate carve-out needs to essentially prevent ISDS claims being brought in relation to climate-related measures. And where such claims are nevertheless brought by investors, the carve-out needs to enable such measures to be dealt with in a process that is controlled by the treaty parties, rather than the application of the carve-out being left to be decided by ISDS tribunals. There is a question of the scope of the carve-out in how you design it, whether, for example, you design a carve-out in terms of the kind or purpose of measures covered, or if you focus on the sectors or industries that are excluded from ISDS or excluded from treaty protection more generally. Whichever way you design a climate carve-out, in my view, you need a process to govern the application of the carve-out, particularly for where, as I said, claims are brought by investors that states view as covered by the carve-out. In short, the benefit of the proposed process that I touched on in my earlier answer that was developed in the work with Elizabeth Schaugg is that the application of the carve-out would be decided in a time-limited manner by decision makers with climate-relevant expertise. That issue would either be determined by a joint determination of the treaty parties' designated environmental authorities, or where they could not agree, either state could refer the question to an independent state-to-state panel, including members with climate expertise. Now, your second question, how could such a climate carve-out be integrated into the regime of old generation treaties? Here, in short, I think there is an important role to play for a plurilateral opt-in reform instrument, because essentially what you want to do is modify numerous existing, mostly bilateral investment treaties through states becoming party to a single plurilateral reform instrument. The treaty law issues involved in a plurilateral reform instrument, which would operate to modify numerous existing investment treaties, are surmountable. Consider, for example, the work that UNCITRALWGIII has already done on a multilateral instrument or on ISDS reform, or a MIA, which, as we heard, is being used as the means to deliver the Working Group 3 proposals. The draft MIA developed by UNCITRAL Working Group 3 includes provision for additional protocols to be proposed at a later point in time and added to the convention if there is political will. So arguably, depending on political will, one day it could be that a protocol is proposed in relation to climate issues and might be added to the convention. The option of a plurilateral reform instrument, which would operate to modify numerous existing bilateral IAAs, has also recently been discussed in some detail in the OECD's Track 2 process on the future of investment treaties. Just finally, in addition to this option of a plurilateral reform treaty, which would modify numerous existing investment treaties, at a bilateral level where two or more treaty parties agree, any carve-out can obviously be introduced either through treaty amendments or in the context of renegotiation of older IAAs.
Thank you very much, Josh. And I would like to, in addition to what you mentioned now with regard to the MIA and other precedents, also point to the multilateral instrument that was proposed and that is implementing the BEPS reform at the OECD. It seems that there's a tendency of several, reform processes that address bilateral or, treaty regimes in such a way. So this is definitely a conversation to follow closely. Turning now to Clémentine, besides the challenges to climate and environmental measures, we increasingly see investors challenge EU restrictive measures and also sanctions, also in most recent cases that have been filed. In various decisions, the European Court of Justice has also pointed to the incompatibility of legacy bilateral investment treaties with the law of the European Union. How, in your view, could a European Commission infringement action regarding the member states' outdated bilateral investment treaties foster a political will to terminate or renegotiate these treaties? And as a second question, what would be the main legal arguments on which such an action would rely?
Thanks, Lukas. I will start by your second question, that what would be the legal arguments on an infringement proceedings? As you mentioned, there is a tendency to use BITs by, for example, Russian oligarchs to target sanctions, and we have one emblematic example now. The Russian oligarch Friedman was subject to sanctions over the Russian invasion of Ukraine, which is using an ISDS to sue Luxembourg, and was demanding 16 billion in compensation against Luxembourg for having his assets frozen. So this is not something theoretical. This is really happening, and this is, from a legal point of view, this is not new. And actually, there is already case law that has been rendered by the European Court of Justice on the interference of BITs, especially the incompatibility of all BITs with EU law. In 2009, the ECJ rendered 3 rulings against Austria, Sweden, and Finland and it clearly ruled that the capital transfer clauses in these investment treaties are incompatible with the Council's powers to unilaterally adopt restrictive measures, i.e. sanctions, with regard to third-party countries. So this is really the example that we have now. And there is another important precedent, which is an opinion issued by the European Court of Justice regarding the CETA, the EU trade agreement between the EU and Canada, and which was rendered in 2019. And in this ruling, the ECJ found that to comply, which was called the principle of autonomy of the EU, ISDS mechanism must not allow arbitral tribunals to interpret or apply EU law, nor to call into question the level of protection of public interests established by the EU institution. And this is exactly what at least all bilateral investment treaties do. So that's why it is quite straightforward that these, at least the legacy BITs, the treaties which has not been reformed to include such clause such as right to regulate or to allow the institution to exercise their right to impose sanctions in certain circumstances, they are very clearly not in line with the criteria set by the European Court of Justice, and so they are not compatible with EU law. And that this is the legal argument that should be used, because as it is very clear in the treaties, the member states are bound by a principle of loyalty, and also for BITs concluded prior to the EU accession, there is Article 351(2), under which member states may take are required to take all appropriate steps to eliminate incompatibilities of their own treaty with EU law. So this is very clear, the legal argument is there. And as we are speaking of already old case law, the one of 2009, the Commission can and actually should take actions to really prompt these member states to act with their uncompliant treaties. So this is to the question. The first one, this obviously will, we've seen with the case of intra-EU disputes that finally, under the pressure of the Commission, finally the member states have acted. They have adopted the agreement to follow the Commission's view. So this is really something which has already done. We see now that this is of paramount importance, because really it interferes with the EU capacity to act for its national security. So all the circumstances are met for the Commissions to act on this. Thank you.
Thank you very much, Clémentine, and to all four of you for this deep dive into the status quo of multilateral and regional reform of ISDS and investment law. So we can see that several processes and efforts are ongoing at various levels, but the question whether they will be able to deliver the scope of reform that is required to meet the most pressing challenges, including the climate crisis, and also the question whether they will be able to deliver within the time that is needed remains an open question to date. With that, I would like to close the panel discussion now and move to answering some of the questions by our audience. At this stage, I would like to remind our audience that they can still add their questions to the Q&A box at the bottom of the screen. And I do see we already have two questions. The first one that is addressed to Dafina, where John Cracknell is asking whether in the World Investment Treaty Report, it says that 80 countries around the world have taken action to try and align their investment agreements with sustainable development, or they are leaving agreements. And he is wondering whether there is a list of these countries available and whether you can say something about these 80 countries.
Thank you, Lukas, and thank you, John, for the excellent question. In fact, there is no list that we could share directly, but these are typically the countries that we see actively engaged in regional reform efforts. I think the calculation that you saw this particular year included the countries that are engaged in the League of Arab States renegotiation of the relevant Arab investment agreement, COMESA members that are currently renegotiating their regional investment treaty as well, and aligning with the African Continental Free Trade Area. Several member states that I would not disclose, but who have requested IAEA reviews and reviews of their model agreements, which also suggest their efforts and their internal work into finding a new approach to investment policies, to international investment policies. These are the members that come to mind as an example currently from where the number in a sense comes from. We don't tend to publish that number, partly because some of the technical assistance and capacity building we do, you can find information on in our reporting, but as they're done for the countries, we don't advertise them widely, and we don't publish the reports for anyone else but for the government officials. But in UNCTAD activity reports, you can find quite a bit of information, for instance, on the countries in question.
Thank you very much, Dafina. And we also have a question by Linda Thompson for Günes. She's asking, could you expand on those countries that seem to be immune to this chilling effect that you mentioned and doing, quote, 1% of what they need to do? Who are these countries, and why do you think that is the case?
I was expecting this question because it is a provocative statement. Just to get it out of the way, I don't know if it's measurably 1% of what they should be doing, but it's a fact nonetheless that they're not doing what they should be doing to its full extent. It's not a secret that we don't have any major economies at the moment aligned with this 1.5 Celsius degrees trajectory. But it's really to emphasize that there is a global implementation gap. And again, this is not a secret. We have fossil fuel producers and high-income economies that have the capacity and really the historical responsibility to act faster. And somehow they remain structurally, politically tied to this carbon-intensive growth. And it's not an absolute necessity for them. This could change going forward. I mean, it's not about naming and shaming. Again, it's not me pointing the finger, but United States, China, Russia, Saudi Arabia, other energy exporters, they continue to expand on this fossil fuel production, even if they pledge decarbonization. China remains largely coal dependent to this day, despite sweeping policies domestically. So again, it's really not about if it's 1% or 50% true. There are also emerging economies, developing countries that have really ambitious targets on paper, but the policies just fall short. And I will take it back to my original point that ISDS is an important indicator, and it is an important aspect of this struggle against this climate change and its catastrophic effects that we are feeling today. Ask any Pacific island country. There are already people suffering from this, right? So it is, again, to attract attention to this reality that these stronger economies, developed economies, aren't doing what they should be doing. I don't think this is a controversial statement. It's measurably, demonstrably correct. About the regulatory chill, again, back to these, some countries have the legal political apparatus, the economic power to defend themselves against cases, and that won't necessarily impact this particular country as it would impact a developing country facing multiple billion-dollar claims by a single investor. Now, I don't know if an absolute immunity exists. Of course, there will be some sort of reaction to the claim. Maybe some policy shifts will take into effect. But overall, for example, if the US faces a claim, I don't really think it will make the US change its entire apparatus or risk the US going bankrupt like it does to certain states, right? Again, this is something demonstrably true. And also there is the political weight that these states carry that many other developing countries, smaller countries, do not carry. And this is also the reality today. So just, just to add, maybe expand upon this, thank you for this question.
Thank you very much, Günes. And I think we have time for one last question. There is one question by Rishika Pardikar. She asks, and she says that one of the things that she hears when she asks if new members that are signing up to the ECT will get locked into a carbon future, is that she sometimes hears the reply that they are signing up to a reform treaty. And so she's wondering how someone could, assess these risks. For example, if an African nation signs up to the ECT, will it automatically mean that it won't be signing up to be sued by fossil fuel investors? Will it not be exposed to ISDS? And I think this question, I can direct it to you, Clémentine.
I'll start, but if someone wants to complete, that could be also good, because it's a complex issue, the modernization of the ECT. And what I can say, it's yes, a new member will sign up to the modernized ECT, but as regards fossil fuel, the exclusion is not completed at all. It's not complete except for the EU. Under my understanding, the modernized text of the treaty only exclude some fossil fuels, which are high temperature coal tar, fuel wood, and wood charcoal, but from the protection, which is not at all fossil fuel, gas, oil, etc. So on this, you cannot exclude at all to be for new parties, even to the modernized ECT, even if there have been some slight improvement. This is not at all a guarantee not to be sued in relation to fossil fuel.
And if I may take the privilege of moderating the discussion to also complement, I think one thing we can see with the carve-out is that it's optional, and only some ECT contracting parties have managed to negotiate one. And the process and the procedural bar for negotiating one after joining is very high, which means any new state signing up to the agreement at a later stage will face very difficult odds of obtaining a similar concession from all the other remaining ECT contracting parties on this carve-out. So yes, new states are facing the risk of ISDS, newly joining states are facing the risk of ISDS, including in relation to fossil fuels under the Energy Charter Treaty. I can see that the time is advanced. Dafina, do you want to briefly comment quickly on this question?
To say that the Energy Charter Treaty is the most litigated international investment treaty based on UNCTAD data. I don't have anything else to add, but it is certainly a consideration to keep in mind when deciding on whether to join or not.
Absolutely. No, I couldn't have put it this succinctly, but clearly there's a significant risk in joining a treaty that many states have withdrawn from at this stage. So with that, I would like to conclude the discussion and also the Q&A session. And I would like to wholeheartedly thank our panelists for joining us today, and also our co-organizers, Client Earth, for this collaboration with this webinar series. I would also like to point out that we have an autumn full of activities with another webinar coming up on October 29th that will unpack the implications of the ICJ's landmark advisory opinion on climate change for investment law and investor state arbitration. So stay tuned and also register to that upcoming webinar using the link that we have just shared on the chat. And so in the name of Client Earth and ISD, thank you very much for joining us today, and I wish you a nice rest of your day. Thank you.